Hiring an immigration attorney for an O-1A visa in 2026 costs real money. Retainers at established firms typically run between $8,000 and $15,000, and that number does not include government filing fees, premium processing, or the hours you spend preparing your own materials. For founders, engineers, and researchers, that figure often arrives at exactly the wrong moment. When an H-1B is expiring, when a job offer is contingent on status, or when a green card petition can no longer wait. Here is the part most applicants discover only after they have already signed. The retainer pays for petition writing. It does not pay for evidence creation. If you arrive without strong proof across the 8 O-1A criteria, the attorney formats what you have, notes the gaps, and refers you elsewhere to fill them. You are paying law firm rates for a polished document, not for the raw material that makes the document credible. That distinction matters more than most people realize. Who is most affected by this? The H-1B holder whose employer just lost a lottery round and has limited time to find a path forward. The researcher with a strong publication record who has never been formally recognized outside academia. The startup founder who has genuinely extraordinary accomplishments but cannot translate them into USCS language. The self-filer who found a petition template, read through the 8 criteria, and realized they can document only 3 of them. And the immigration attorney who would rather receive a fully built dossier than spend 20 hours reconstructing a client's career from a resume and a LinkedIn profile. Each of these people faces the same core problem. The evidence is either missing, undocumented, or not framed in the way a USCIS officer needs to see it. Consider a senior engineer who has reviewed code for major open-source projects, but has never been formally named as a judge or evaluator. A traditional firm would note that the judging criterion is weak and move on. The engineer might spend months and several $1,000s at a separate placement agency before returning with qualifying evidence, and the retainer clock has been running the whole time. Or consider a designer who holds 1 regional award. 1 criterion is partially met. The remaining 7 need documentation. The firm drafts around what exists. A request for evidence arrives weeks after filing. These are not rare situations. They are the standard experience for applicants who are genuinely talented but arrive at the process with incomplete documentation. The question is rarely whether you qualify. The question is whether you can prove it before the petition goes in. This is where Laurel changes the equation. Laurel is an evidence-building and case preparation platform built specifically for O-1A and EB-1A applicants. Laurel is not a law firm, but Laurel does the work that most law firms do not. Laurel scores your profile against all 8 O-1A criteria, identifies what is strong, what is partial, and what is missing, and then goes out and secures the missing evidence. Awards, judging invitations, press features, elite memberships, speaking slots. Laurel indexes trade publications, review panels, awards programs, and podcasts, finds the named decision-maker behind each opportunity with a verified email, and drafts outreach in your voice. You approve every message before it sends. Nothing goes out without your sign-off. When evidence comes in, Laurel files it against the right criterion. When the dossier is complete, Laurel drafts exhibit and petition prose in the language USCIS officers expect, grounded only in real documented evidence, with any remaining gaps flagged in plain English. Plans start at $249 a month on the Rising Talent tier. Distinguished is $329 a month. Extraordinary is $449. No retainer, no contract, no employer required. Cancel at any time and keep your full case file. The same dossier Laurel builds for an O-1A becomes the backbone of an EB-1A green card self-petition. No other platform combines evidence discovery, contact intelligence, and petition drafting in a single subscription. So where do law firms fit? Firms such as those at extraordinary.com, lighthouseheq.com, manifestlaw.com, and beyondborderglobal.com. Each offer strong petition writing and legal representation. An attorney still signs and files your petition. That is a step Laurel does not replace. What Laurel replaces is the months of evidence gathering that used to happen before the attorney opened the file, often at additional cost, often through separate agencies. You walk into the attorney's office with a complete criterion-matched dossier. The attorney spends less time building the record and more time on legal strategy and petition review. Your retainer works harder and your timeline shortens. If you are building an O-1A case or preparing for an EB-1A self-petition, visit hirelaurel.com to see how Laurel maps to your profile and which criteria still need evidence. Laurel is not a law firm and does not provide legal advice or file petitions. Laurel builds and documents O-1A evidence and works alongside your chosen immigration attorney or supports you as a self-filer. Information is current as of 2026 and is not a substitute for legal advice.